My name is Jeff Morgan. I am from Dallas, Texas. The Texas Code of Judicial Conduct, as amended by the Supreme Court of Texas through July the 10th, 2019, talks about the importance of having an honorable judiciary. In the second paragraph, it says this: the Code of Judicial Conduct is not intended as an exhaustive guide for the conduct of judges. Very important that the Texas Code focuses on the conduct of judges. The Texas Code of Judicial Conduct focuses on the conduct of judges. They should also be governed in their judicial and personal conduct by general ethical standards. The code is intended, however, to state basic standards which should govern the conduct of all judges, every single judge, all judges, and to provide guidance to assist judges in establishing and in maintaining high standards of judicial and personal conduct. So it started to list some canons about the judicial conduct. Canon number 1 says this: upholding the integrity and independence of the judiciary. An independent and honorable judiciary is indispensable to justice in our society. An independent and honorable judiciary is indispensable to justice in our society. A judge should participate in establishing, maintaining, and enforcing high standards of conduct and should personally observe those standards so that the integrity and independence of the judiciary is preserved. One of the issues that we find in Texas is that there are accusations that judges are not acting in a high ethical manner, and when they judge, they don't even judge in a high judicial manner. So we have a crisis of confidence in Texas in our judicial system because not all judges uphold these high ethical standards that they should be applying in their judicial and personal lives. The provisions of this code, again, are to be construed and to apply to further that objective, that judges would actually have these high moral standards, these high standards of conduct, and that they would observe these conducts so that integrity and independence of the judiciary is preserved. So the integrity and independence of the judiciary is preserved not by the litigants appearing before the judge, but by the judge and his conduct or her conduct. Now the second canon says this: Canon 2, avoiding impropriety and the appearance of impropriety in all of the judge's activities. And it says further, a judge shall comply with the law and should act at all times that promotes public confidence in the integrity and impartiality of the judiciary. So in other words, a judge should not come into a setting with a predetermined decision in mind, and I know of many cases in which that appears to have been the case. The judge needs to act with integrity so that the public's confidence is maintained. Once again, the integrity and the impartiality and the independence of the judiciary is not dependent upon the litigants or the people appearing before the judge, whether it be a petitioner or a respondent, whether it be a plaintiff or a defendant. The independence, integrity, and impartiality of the judiciary is maintained by a judge acting with high ethical standards. Now, in the Rules of Judicial Administration, and this was updated May the 2nd, 2017, Rule 12 says this: public access to judicial records. 12.1, the policy says the purpose of this rule is to provide public access to information in the judiciary consistent with the mandates of the Texas Constitution, that the public interests are best served by open courts, open and transparent, and honest courts that have judges with very high ethical standards, both personally and professionally. The public interests are best served by open courts and by an independent judiciary. The rule should be liberally construed to achieve its purpose. So maintaining the confidence of the judiciary and our judges and the whole judicial system, it's very important. It is a very important goal that we are seeking to uphold, and judges are responsible to ensure that the public has great confidence in the integrity impartiality and independence of the judiciary. So yesterday I went down to a case that was held in Tarrant County, and it is cause number C44689. I'm not going to read what it's about, but it did take place in Tarrant County. And prior to this order that was given by the judge, I actually wrote a letter because I thought, we do need to make sure that the judiciary is acting in a manner of integrity. We have heard many cases about judges sometimes telling a court reporter to not include something in the transcript. We have seen times, and I know I've experienced personally, when a judge acted as if he was trying to beat up the person, as Justice of the Peace Jack James did to me. I have beaten you up enough, is what he said. And I've seen this happen with other people, and I've heard other people talk about how the judiciary acts in less than honorable manner. So I wrote a letter to Jennifer R. Ramos. She is the 96th District Court Coordinator for the Tom Vandergriff Civil Courts Building. This is in Fort Worth, Texas. And here's what I wrote in the letter. Dear Miss Ramos, my name is Jeff Morgan. I have produced over 800 videos on a wide range of matters pertaining to no-fault divorce, the family court, shared parenting, parental and grandparent alienation, the impact of fatherlessness on our children, CPS reform, and other related matters. In April of this year, I was given the Ruth Institute's first ever Divorce Reform Activist of the Year. When the Texas Attorney General Ken Paxton held a meeting on child support enforcement in Austin in December 2017, his office contacted me to facilitate the meeting. I had been one of the major proponents and organizers for several bills presented before the Juvenile Justice and Family Issues Committee, both in the 85th and 86th legislatures. I have spoken with numerous representatives and senators on the state level and presented testimony on numerous occasions in various bills in Austin. I have spoken with leaders in nationwide organizations such as the Family Research Council, as well as state organizations such as Texas Values. As part of my ongoing efforts to help bring about discussion and reform of our family courts, because of course the public interest is best served by having courts that the public can trust in, courts and judges that uphold the highest standard of integrity and impartiality and independence. As part of my ongoing efforts to help bring about discussion and reform of our family courts, I would like to videotape the hearing to be held on Thursday, August 15th, 2019 at 1:30 p.m. in the 96th District Court in Fort Worth, Texas, for the motion of recusal of presiding Judge David Evans. Videotaping this recording, I should have said proceeding or hearing, videotaping this recording will be beneficial to give the public a better understanding of what occurs in such a hearing, and it will help our legislators understand some of the challenges that litigants face. My equipment is relatively small, so I can easily station myself in a very unobtrusive location. As part of my ongoing effort to educate the public, I will make the video available to all free of charge. What protocols do I need to follow to videotape the proceedings? Thank you for your time and advice. Yours truly, Jeffrey S. Morgan. Now, in the Texas Rules of Civil Procedure, Part 1, the general rules, go now to Rule 18C, recording and broadcast of court proceedings. A trial court, and this was not a trial court, this was just a hearing, a trial court may permit broadcasting, televising, recording, or photographing of proceedings in the courtroom only in the following circumstances. A, in accordance with the guidelines promulgated by the Supreme Court for civil cases, or B, when broadcasting, televising, recording, or photographing will not unduly distract participants or impair the dignity of the proceedings, and the parties have consented. And consent to being depicted or recorded is obtained from each witness whose testimony will be broadcast, televised, or photographed, or C, the broadcasting, televising, recording, or photographing of investiture or ceremonial proceedings. So of particular importance to the proceeding that we were at was point B, when broadcasting, televising, recording, or photographing will not unduly distract the participants or impair the dignity of the proceedings, and the parties have consented, and consent to being depicted or recorded is obtained from each witness whose testimony will be broadcast, televised, or photographed. So to the credit of Ms. Ramos, she sent my request to the presiding judge, Judge R.H. Wallace, Jr., the judge who was presiding over the hearing. And he issued this order that he submitted to Brandon Johnson. Brandon Johnson was the sole party who was testifying in this hearing. And also he presented the order to the opposing party, which was basically the attorney, Amy Bryan, who was representing Judge David Evans. Judge David Evans did not appear as he was requested to appear, so he was not there. So he basically had no testimony to give. And Ms. Bryan gave no testimony, to the best of my knowledge, regarding the hearing. Mr. Brandon Johnson did give the testimony, and Mr. Brandon Johnson consented to being videotaped. The order says this is to advise the parties that the court received an ex parte communication related to this proceeding from Mr. Jeffrey S. Morgan. That communication, consisting of 2 pages, is attached to this order. The court will consider this as a request to record or photograph the hearing on the petitioner's motion for recusal set for hearing at 1:30 p.m. Thursday, August 15th, 2019, and will rule upon the request at that time. The parties will advise the court as soon as practical prior to the hearing whether they and each witness whose testimony may be recorded consent to such recording. See the Texas Rules of Civil Procedure 18CB. This was signed the 13th day of August 2019. So this order was signed 2 days prior to the hearing taking place, again by R.H. Wallace Jr., who was the judge presiding. To go back to the email that I actually sent to Ms. Ramos, Ms. Jennifer Ramos, again, very short and brief. My name is Jeff Morgan. Per the attachment, I am requesting accommodations to videotape the hearing for motion to recuse C44689, scheduled to be heard on Thursday, August 15th. Thank you for your assistance in this matter. Please let me know if you have any questions or concern. Yours truly, Jeffrey S. Morgan. So I did take time off of work to go and drive to this hearing in Tarrant County. It took about an hour to get there, and I was there in plenty of time with my equipment. As I walked in the court to set up the equipment, the bailiff, I believe it was, told me that I had to station my equipment outside, that I had to put it in another room. So I had 2 video cameras with tripods, and I did set them in a conference room outside. The judge came in, all rose as we were supposed to rise for him, and one of the first orders of business that he took care of was this pertaining to this order. Now he asked Mr. Brandon Johnson, do you consent to this? And Brandon, of course, did. Then he turned to the other party, which would be the counselor, Amy Bryan, the attorney for Judge David Evans. Now, I don't know why, but Miss Bryan refused to consent to allow me to videotape the recordings. The interesting thing is that Miss Bryan had nothing to say, to the best of my knowledge and recollection. She had nothing to say as far as testimony on behalf of the judge. She just did not want to give her consent to have the proceedings videotaped. And I don't know why that is. When we talk about open and honest and transparent courts, we should allow videotaping to take place in more instances. In fact, as the rules for judicial administration say, that these rules, in my opinion, should be liberally construed to achieve its purpose, because the public interests are best served by open courts and by an independent judiciary. And what better way is there to have open courts and to ensure that our judiciary is independent than by videotaping them? So that if we do have some concerns over what they have done in court, or maybe if they have acted in less than ethical manner, or maybe if they have abused their position, we would actually have a videotape that we could go back and observe it. And not just the people that are involved, but perhaps an independent counsel who could say, well, Judge, it looked to me like you were a bit abusive or threatening in this situation. So I could not videotape the recording. Miss Bryan, once again, she did not give her consent. And again, I don't know why. I don't know what she had to hide. Mr. Johnson, who was there, was very open and transparent. But Miss Johnson, I guess for some reason, felt that even though she would be saying nothing on behalf of her client, and her client did not show up as he was asked to do by Mr. Johnson, that somehow videotaping might hurt their cause. And I don't understand that, nor do I understand why the judge allowed her to shut down the videotaping. But he did. Nevertheless, he did. So going back to the Texas Rules of Civil Procedure, 18C, the recording and broadcasting of court proceedings. Again, this is a trial court they're talking about here. A trial court may permit broadcasting, televising, recording, or photographing of proceedings in the courtroom only in the following instances. The only thing under consideration, according to the judge's orders, was when broadcasting, televising, recording, or photographing will not unduly distract participants or impair the dignity of the proceedings, and the parties have consented. And consent to being depicted or recorded is obtained from each witness whose testimony will be broadcast, televised, or photographed. The concern of the Texas Rules of Civil Procedure is that somehow videotaping or televising or broadcasting proceedings might impair the dignity of the court. My contention is that videotaping these proceedings would actually enhance the dignity of the court. What I saw yesterday shocked me. At the end of the hearing, I saw the judge, which in my mind, in my opinion, and also in Mr. Johnson's opinion, threatened him. The judge said to Mr. Brandon Johnson, "Mr. Johnson, where do you live?" To which Mr. Johnson said, "Sir, I live in Mineral Wells." The judge said, "Do you want to go home tonight?" I was shocked. I took that as being a direct threat. Mr. Johnson, shut up, or I am going to have you put in jail for this evening. Shut up, or I am going to have the bailiff haul you away. Now, I talked with Brandon Johnson afterwards, and that is the same way that he felt. He went to the judge in good faith, wanting the judge to rule on something, and the judge, in my opinion, abused the faith that Mr. Johnson had in him. In fact, the judge, in my opinion, acted in an abusive manner.
But the judge asked me, he says, "Where do you live?" And I said, "Well, I live in Mineral Wells." And then he said, "Do you want to go home tonight?"
Well, sir, Mr. Johnson, listen, where do you live? Sir, I live in Mineral Wells. You want to go home tonight? You want to go home tonight? You want to go home tonight?
Now, how could we find out whether my opinion is right or whether we're just supposed to believe the judge who said, "Mr. Johnson, do you want to go home tonight?" and used it, in my opinion, as a threat? Video recordings would be very, very useful in our courtrooms, not to impair the integrity of the courts, but actually to enhance the integrity of the courts. So I'm hoping that these legislators that we have in the state of Texas, both representatives and senators, will consider this, that perhaps what we should be doing is having more videotaping of the courts and these hearings that take place, especially in civil courts and family courts, because a lot of stuff gets done that people don't see, that the legislators only hear about, but there's no proof. If we had videotapes of what was going on, we could hold these judges accountable. In fact, I would also say perhaps we should then submit these videotape recordings to the Texas State Commission on Judicial Conduct. You see, if you are in front of a judge, you're not supposed to videotape anything. You're just supposed to accept whatever the judge says. You're supposed to accept that the transcripts that you may have requested are truthful, even if the judge may have told the court reporter, scratch that, delete that from the record, do not include that. You're supposed to trust that. How can a litigant, whether it be a plaintiff or a defendant, a petitioner or a respondent, know what is actually being done is right without a record? We need cameras in our courtrooms. We need video cameras, not just to protect the litigants that are in front of the judge, but we need cameras to make sure that our judges are acting in high ethical manners, in an independent, in an impartial manner, and with integrity. Because right now in Texas, many people have very little confidence, very little faith in the judicial system. One small step that we could take to restoring confidence in the judicial system would be to install video cameras in the room to videotape the judges to see if they are acting with integrity, impartiality, and independence. Furthermore, when the legislature is in session, all of the committee hearings are actually videotaped. Videotaping plays a very important role in our society to ensure that integrity is taking place. It makes sure that our representatives and our senators are held accountable for what they do and what they say. That any citizen in the state of Texas, actually nationwide, can go to these videotapes and see how a representative or a senator acted. Why do judges get a pass on this? Why are judges exempt from having some type of accountability so that we can actually judge their actions, that we can actually judge their speech, that we can actually take a look at what they say when they threaten a man in court, or when they talk about how we beat somebody up, or when they say one thing and do another, or when they tell a court reporter to strike something from the record? Why should judges be held to any less of a standard than our representatives and senators are held to? And actually, when people appear before the House committees or the Senate committees to give testimony, everyday citizens are being recorded, and their testimonies are forever cemented before the public in videotape format. Why are our judges the only ones exempt from this requirement? A lot of dastardly deeds can take place in our courts. Judges issuing threats to people that appear before them, threats that you'd better shut up or you might go to jail. That's the way I took it. That is the way that Brandon took it. That is the way I believe the record would reflect it if we had a videotape. A videotape would have enhanced the integrity, the independence, and the impartiality of the court. I doubt whether Judge R.H. Wallace Jr. would have done or said what he said had he known he was being videotaped. Right now, with no accountability, with judges who can say and do whatever they want to with impunity, it is no wonder that the people of Texas do not trust the judicial system. Videotaping judges, videotaping proceedings in the courtroom would help to restore our faith in the independent, impartial judiciary and in the integrity of the system. Thank you.
Mr. Johnson, listen, just a second. Where do you live? Sir, I live in Mineral Wells. You want to go home tonight? You want to go home tonight?